And is that on behalf of the people?
What your assistant public defender would talk about was held on behalf of Mr. Covington. Yes, ma'am.
Pardon, Your Honor. Sean Covington.
Thank you. What are we doing?
We would have to go here on this matter for discovery.
And Your Honor, I would like to respond.
Go ahead.
Welcome back to Trial Truth, and this hearing wastes absolutely no time diving straight into chaos. Right out of the gate, prosecutors are painting a picture of a defendant who wasn't just accused of violent behavior, but someone they believe repeatedly ignored court obligations while allegedly creating serious safety concerns for the victim. And pay attention here, because this case instantly becomes bigger than a normal bond argument. The court is now balancing multiple issues at once: alleged violence involving a firearm, questions about the defendant's reliability, prior warrants, missed appearances, and concerns about whether the victim is actually safe if this man walks free again. That combination is exactly what makes judges tense in these hearings. You can already hear the prosecution building toward one central argument. This isn't somebody we trust outside custody. And in courtroom language, trust is everything. Once a judge starts doubting whether someone will appear in court or follow conditions, the entire tone of the hearing changes fast. What also stands out is how early the state introduces emotional stakes, mentioning a child allegedly being present during the incident. That's strategic. Prosecutors know details like that immediately increase the seriousness in the courtroom atmosphere.
Your Honor, at this time, the people will be requesting that the defendant's bond be modified to the original 100,000 cash surety passed at arraignment. This defendant failed to appear at 2023 in this case and exam and proper witness. He was also out on probation for stalking and picked up 2 felony charges, I believe. And I believe in this case, he was released on May 7th, and it showed on, actually still has a warrant for a VOP, other non-support warrants. And the people believe that in this case, the bond would be appropriate at 100,000 given the serious nature and concern for the victim's safety. In this case, the victim and defendant come in, the defendant was at the residence with their daughter. The victim picked her up. The argument began while they were arguing. The defendant pulled the gun from his waist, cocked the gun as if to load around, pointed it at the victim and also at their car that their child was in. The victim was in fear for her life, and he struck her with the gun 3 times and then fled. When the officers talked to the victim, she had noticeable swelling above her left temple, a cut above her ear, and blood on her shirt. These were also concerned given the defendant's past history of assaultive and domestic violence charges, as well as dismissed domestic violence charges. So maybe asking that the bond be set at 100,000.
Response.
Your Honor,
How did he come into custody?
Your Honor, I was in Detroit.
Okay. How'd you get into custody? Did you walk in or were you picked up?
I was picked up in Detroit.
Mr. Allen.
A case out there. And then I handled all the case. I came out here. I got discharged off of probation. I had to stay in Washington County for about 7 years. So when it came in,
Your Honor, he was picked up originally, but I think that this second attempt at bond increase, the second bite of the apple, he was released. He's coming to court today. He's ready to.
This is where the defense starts trying to reset the narrative before it completely spirals out of control. Notice the strategy here. Instead of focusing only on the allegations themselves, defense counsel is trying to frame the defendant as cooperative, present, and finally taking the process seriously. In other words, yes, things got messy, but he's here now. That's the argument. But here's the problem. Judges rarely focus only on today's behavior when there's a history of missed appearances floating around the case. Courts look backward just as much as forward. And you can already feel Judge Simpson becoming skeptical about the timeline. The second the discussion shifts from "he's here now" to "what happened while he was out," the entire hearing becomes less about sympathy and more about accountability. This is also one of those moments courtroom viewers should pay attention to because bond hearings are often psychological battles. Prosecutors push danger and risk. Defense attorneys push rehabilitation and compliance. The judge sits in the middle, trying to figure out which version is more believable.
But hold it. While he was out, basically absconding on this case, my understanding is he picked up other cases.
That's the people's understanding. While he was on probation for aggravated stalking, the judge slaves court.
Those are support cases, if I'm correct. Yeah.
Or it might be on 14. But our notes had that he had a video hearing on 5/2, the judge said.
The initial was a failure to appear when we were before. I think I did that arraignment for him. And there were 2 months of time where he was in the hospital, if I recall, and he suffered some burns as the court made clear.
Hold on a second. Because back, just looking for a date on this, I don't know that the defendant just didn't come into court. He was incarcerated in Wayne County.
Now the judge starts drilling directly into the timeline, and this is where hearings can completely turn against a defendant. Judge Simpson is no longer casually listening, he's auditing the story. Every missed date, every incarceration period, every hospital stay, every communication with the court is now being examined piece by piece. And this matters because judges absolutely hate uncertainty when it comes to appearances in court. If the timeline sounds inconsistent or incomplete, credibility starts collapsing quickly. The defense is trying to explain delays through medical issues and confusion surrounding representation, but the judge is clearly asking himself a different question. Even if some excuses are valid, do they explain all of it? That distinction is huge. One thing experienced courtroom viewers recognize immediately is when a judge stops reacting emotionally and starts reacting mathematically. Judge Simpson is literally counting months, appearances, and gaps. Once a judge enters that mode, bond reduction becomes much harder because the court starts focusing on patterns instead of isolated excuses.
January of this year. And then proceeded to send us information for a plea by mail. Requesting a trial date, review of bond with a request for dismissal due to the hearsay clause, and Washington County has no jurisdiction over me. Because he's a permanent resident of Wayne County. Yeah, go ahead.
At the arraignment, we were going back and forth with our magistrate Pink and I, and she said, I won't quote her exactly, but the summary of it was, let him out on bond because some of it was confusion. He should be holding himself to the same standard as an attorney, but this was kind of an attempt at self-representation that went horribly wrong. And so as you can see, he's here now with an attorney. He's coming into court to address these charges, to address everything that's happening. He's not a flight risk judge. He's here now, so I would say that
He's not a flight risk? Where was he?
He was in the hospital for 2 months, Your Honor.
When?
The court date in question, I remember it was April 4th, and he was in the hospital at that time.
Now, your assistant prosecuting attorney, Morgan Barroso, and I have the people looking back at our notes. What we see is that this is a 2022 case.
Here comes the prosecution's strongest stretch of the hearing so far, because now they're bringing receipts. Instead of speaking generally about concerns, the prosecutor starts laying out exact procedural history, dates, failed appearances, prior attempts to proceed, Zoom complications, bench warrant status, and that level of specificity carries weight inside a courtroom. This is important because judges rely heavily on documented chronology. Emotion matters, but timelines matter even more. And the prosecution is building a very clear narrative. The system attempted to move this case forward multiple times, but the defendant allegedly failed to cooperate consistently. What really hurts the defense position here is the mention of the defendant mailing in plea paperwork while already in custody elsewhere. Why? Because it suggests awareness of the court process. Once awareness is established, arguments about confusion or misunderstanding become less persuasive. And you can actually hear the courtroom momentum shifting. Earlier, there was room for sympathy regarding hospitalization, but prosecutors are now narrowing the focus to the unexplained months outside that hospital period. That's the danger zone.
He was set for exam pro se on March 7th. The victim was present, willing, and cooperative. The defendant appeared on Zoom. The court, they tried to proceed with the exam at that date, but the defendant had insurmountable technical difficulties, so it was adjourned out to April 4th. And on April 4th, the defendant didn't show up.
Did not
show up. He failed to appear, and he was put in bench warrant status. After that, on the 11th of April 11th of 2024, over a year later, he's in custody in Wayne County and mails in the misdemeanor plea by mail to the court.
correct.
So he's in bench warrant status for over a year. And obviously there's something else, other context with law enforcement going on because he's in custody in Wayne County during that time while in bench warrant status. I'm sympathetic to him being in the hospital for a couple of months in there, but that doesn't explain the other 10 months plus where he was in bench warrant status and failed to turn himself in. At this point, I think that there's an issue with his bond being where it is and with him being out of custody, at least without having a GPS.
Well, but he didn't appear for a preliminary examination.
Correct.
This lawyer informed me that I have a case in Washington County for a different reason. So at that same time, my lawyer told me to call down here, get on video camera. I was doing everything on video camera from the hospital.
This exchange is incredibly revealing because the defendant is now personally trying to explain his side directly to the judge, and sometimes that helps, but sometimes it makes things worse depending on how the court receives it. Judge Simpson is laser-focused on one issue, the missing gap after the failed preliminary exam. The defendant keeps returning to the hospital explanation, but the judge keeps steering the conversation back toward the months afterward. That tells you the court isn't debating whether the hospitalization happened. The court is debating whether the explanation covers the entire period of non-appearance. And then comes one of the most relatable analogies of the hearing the cell phone bill comparison. The court's underlying point is simple. When people care about resolving something important, they usually take active steps to fix it. Judges use analogies like this all the time because they're trying to strip complicated legal excuses down to common sense behavior. But here's where tension spikes. The defense attorney attempts to soften the situation by arguing the defendant lacked representation and tried to handle things himself. Judge Simpson immediately pushes back. Hard.
I saw you one time on the camera. So
It wasn't my preliminary examination.
because I was in the hospital, so technical reason for the computer stuff.
No. So then, after you missed the preliminary examination, what took you so long to turn yourself in? Well, you didn't turn yourself in, you got picked up.
It's like Magistrate Garwood says all the time. I tell this to my clients. I said, look, if your cell phone bill goes out, if cable goes out, you're gonna pick up the phone, you're gonna call that and get that resolved immediately. And
I don't know if quoting Magistrate Garwood is convincing to me.
but what I'm saying is, Your Honor, I explained this to him. He wasn't represented before. He didn't understand. He tried to represent himself.
Oh, I think he understood. He understood the date. He's giving me his excuse that he's in the hospital, and then we don't see him for 10 months. And I don't know why a bond was set when we finally get to him in the amount that it's set at. That's in my opinion, that's a clear abuse of discretion. He didn't appear for two court proceedings. Well, appeared at one. He wasn't, I don't think, supposed to be appearing via Zoom. I think Judge Perry did the best she could and then couldn't proceed with that. And then he was supposed to appear, didn't appear, and then disappears. And I think has committed other offenses, because what was he locked up in Wayne County for?
It was a obstruction of justice, and I took care of that case. I came back here, I got dismissed off probation. Judge me, but bear with me because I lost my lyrics, I lost my whole day. So I had to get my body together. And then I promised her I'll come back and take care of this because I need this time.
At this point, Judge Simpson has essentially reached his conclusion, and you can hear it in the tone shift. The court is no longer exploring possibilities, it's explaining consequences. The judge acknowledges the defendant's injuries and hardships, but immediately pivots back to the core issue: repeated failure to appear and failure to voluntarily return to court. That distinction matters enormously in bond hearings. Courts can sympathize with personal struggles while still deciding someone is too unreliable for release, and that's exactly where this hearing is headed now. Judge Simpson is drawing a hard line between hardship and accountability. From the bench's perspective, the defendant didn't resolve the situation himself. Law enforcement eventually resolved it for him by taking him into custody. And honestly, when judges start using phrases like abuse of discretion, alarm bells should go off for the defense. That language signals serious frustration with the original bond decision. It means the judge believes the previous release conditions may have been far too lenient considering the procedural history.
I lost my whole day, as you can see.
I understand that. I'm glad it's worked for you. All I'm saying is you haven't appeared at these proceedings. You didn't turn yourself in. You got picked up, and that's the only reason that you're here. Otherwise, we would probably not be seeing you. As I've said, I think it's an abuse of discretion that this bond was set as it was. Your bond now will be $50,000 cash surety, defendant's remanded. Did I send it to you? I did not. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m. Court does call the case People versus Yusuf Cyrus. Who is this? Who? Far out? Oh, here. Hang on. Ooh, bring it back. Yeah. Step back a second, sir. I'm sorry. Court does call the case of People versus Mohammed Farah. Okay, what are we doing? Discovery's complete.
The courtroom pace shifts quickly here as Judge Simpson moves into another case. And this is something many viewers don't realize about real courtroom calendars. Judges are constantly switching mental gears between entirely different legal situations within seconds. Even though this section sounds more procedural, these moments still matter because they reveal how judges manage control, scheduling, and bond considerations across multiple defendants in a single session. You'll notice how efficiently the court handles discovery status, witness availability, and scheduling for preliminary examination. There's very little wasted movement. But then the bond issue surfaces again, and immediately the tone tightens. The phrase chicken or the egg perfectly captures the court's frustration with overlapping custody issues and multiple pending matters. Judge Simpson is basically saying, why would I adjust this bond if another unresolved issue is already keeping the defendant in custody? That's a major reality in criminal court. Cases rarely exist in isolation. One pending firearm matter, probation issue, or separate warrant can completely affect how judges evaluate release in another case.
Of course you would. Discovery is complete. People had their witnesses available the 21st. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Thank you. Regarding bond, the department does have another matter. Your limit bond is $2,625. He tells me that he intends and they both that if he's granted a PR on this case.
Did he post it?
No, he doesn't intend to if the court is inclined to grant him a personal bond on this matter. He does have.
So we get into a chicken or the egg, because I'm not moving it if he's got another bond.
And other cases of CCW use.
Thank you.
That's correct, Your Honor. Would it be more appropriate to raise that preliminary examination after he posts the bond on the other matters?
I would think so. Judge Valvo would be more than happy to hear it.
Thank you.
At this time, motion for bond reduction is denied. Bond will continue. Thank you. Clerk recalls case Peter versus Yusuf Sire.
Taking it directly.
Thank you.
Your Honor, we're just asking for a 3-week adjournment to submit mitigation information to that here at Barroso for consideration.
May 30th, 2024, 9 a.m. without objection. Bond continued. Thank you. Court calls the case People versus David Davis.
People. Good morning, Your Honor. Judge Overwater, this is public defender on behalf of Mr. Davis. Approaching. Mr. Davis, would you state your name for the record? Mr. Davis.
What are we doing?
Worked out a plea agreement. Plea form was sent to the court last night.
A plea form that indicates he's going to plead to attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 are dismissed. That's the court's entire understanding of the agreement.
Correct.
Now we move into a plea hearing, and the energy changes dramatically compared to the earlier bond arguments. Instead of debating risk and credibility, the court is now focused on making sure the defendant fully understands the rights being waived and the exact terms of the agreement. This is one of the most important parts of any criminal proceeding because guilty pleas must be entered knowingly, voluntarily, and intelligently. That's why Judge Simpson slows everything down and walks through every component carefully: the charge, the possible penalties, the dismissed counts, future sentencing, and the constitutional rights being surrendered. And viewers sometimes underestimate how serious this moment is. Once a plea is accepted, the legal landscape changes completely. Trial rights disappear. Appeal options narrow. The case moves from, can the state prove it, to what sentence will follow. What's also interesting here is how methodical the judge becomes when discussing the advice of rights form. Courts create records like this intentionally to protect the plea later from being challenged. Every "do you understand?" question is building a procedural shield around the agreement.
Yes, sir.
7 sworn.
You sound swear to further testimony about the truth and all the truth self God.
Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that? All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in 14A2 District Court. All right. Understanding all of that, you still wish to plead guilty? And to that charge, how do you plead? Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will and because you believe that you are indeed guilty of this offense? On the date of February 29, 2024, at the location of Buckingham Drive near Hamlet Drive, Superior Township, Washtenaw County, State of Michigan, did you come into contact with Washtenaw County Sheriff deputies? What happened?
I was in the garage, I couldn't come out of the garage, and I waited.
How'd that work?
This portion of the plea hearing becomes surprisingly important because the court still needs a factual basis for the guilty plea. In plain English, Judge Simpson must establish that the defendant actually committed conduct supporting the offense before accepting the plea officially. And notice how carefully the judge phrases these questions. He's not looking for a dramatic confession, he's looking for legally sufficient admissions. That's why the focus narrows onto the lawful command from deputies and the defendant's refusal to comply immediately. These exchanges can sometimes feel awkward because defendants often want to minimize behavior while still accepting a plea deal. But courts need enough factual acknowledgement to support the conviction. So the judge keeps tightening the questions until the required legal elements are clearly established. What also stands out is how calm the courtroom becomes compared to the earlier hearings. No heated bond debate, no argument over missed appearances, just a procedural march toward resolution. But don't mistake calmness for insignificance. Guilty pleas are often the single most consequential moment in a criminal case.
Yeah. You kind of came out of the garage. Yeah. You have no dispute they were giving you a lawful command to come out of the garage, do you? You're not disputing that it was a lawful command they were giving you to come out of the garage. You just didn't come out. Well, not. But you eventually came out. Yeah. Counsel, I complied with the court rule. Would it be proper to accept this defendant's plea?
Defense is satisfied, thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be when? July 9th, 2024. What time? Doesn't matter. 10 a.m. Before Judge Barr. Bond continue.
Thank you, Your Honor.
60 days. It's 2 months. Okay? Emily, I'm just counting. I don't know. Court calls case People versus Wayne Franklin.
Water.
Your name, sir. Thank you. What are we doing?
Your Honor, that's set this matter for preliminary examination. I would ask the court also to consider a bond.
This next hearing escalates fast because now we're dealing with allegations involving stalking behavior, no contact violations, and accusations that the defendant repeatedly ignored court-imposed restrictions. Prosecutors know those facts immediately grab judicial attention because violations of protective conditions strike directly at court authority. The defense tries to present stabilizing factors: employment, family support, local ties, financial responsibility, all classic arguments aimed at showing someone can safely remain in the community. And under normal circumstances, those points absolutely matter. But then the prosecution counters with a timeline of alleged repeated violations after release, and that's devastating in bond court. Why? Because once someone is accused of violating conditions while already on release, judges start wondering whether additional conditions would make any difference at all. The prosecution's argument is carefully constructed here. They're not just alleging contact. They're alleging deception, repeated communication, physical appearance at the residence, and behavior serious enough that neighbors allegedly noticed and recorded it. That combination changes the atmosphere immediately.
Discovery complete on both cases. People have their witnesses available the 21st. preliminary examination will be set in person, May 21st, 2024, 9 a.m. before Judge Valvo. As to bond.
Your Honor, it's my understanding that the complaining witness in this matter is likely left the state. She does not reside with my client. He has his own place that he'd be staying at. My client has 2 jobs. He works for a cleaning service called Arrow Cleaning, where he works nights. He also works at AF John, where he's a property manager for various strip malls. He indicated he resides on Alpine Drive. His mother also lives locally. He has her support. I'd ask the court to consider releasing Mr. Franklin, personal recognizance bonds. We have to comply with the tether requirements that court felt that if they were necessary. The allegations in these cases are not particularly aggravating. There's been, to my knowledge, no indication that he's had any contact with complaining witness since he's been incarcerated. So I would ask the court would be willing to consider his release today. He has reported to me that he is the only provider for his family. His wife does not work, and if he continues to be incarcerated, he will lose his role with his jobs.
Respond.
I first want to note out the gate that he has bonds denied out of 15th District Court, and that is not up until May 15th. But on the attempted home invasion case between April 7th and April 11th, the defendant assaulted and stole the victim's iPhone. The defendant was released on a PR bond on April 19th. It was prohibited from having contact with the victim or going to the residence. On April 24th, he told the victim that he was allowed to have visitation with the children and came to the residence. The victim, after that, then called the court and learned that what the defendant told her was a lie. The defendant has repeatedly harassed and texted and called the victim, resulting in aggravated stalking charges in the case 24 F55094.
This may be the prosecution's most damaging sequence in the entire hearing because the allegations now focus directly on violating a no-contact order, one of the fastest ways to lose credibility with a court. Judges take protective orders extremely seriously. From the court's perspective, those orders are not suggestions or negotiable misunderstandings. They are direct commands. So when prosecutors begin describing repeated calls, texts, appearances at the residence, and alleged manipulation surrounding visitation claims, the concern level inside the courtroom skyrockets. And notice how the prosecution strategically reads one of the text messages into the record. That's not accidental. Reading communications aloud humanizes the allegations and gives the court something concrete to evaluate emotionally and factually at the same time. The defense attempts to narrow the issue by arguing the allegations rely heavily on the complaining witness's statements and by challenging aspects of the home invasion narrative. But by this stage, the courtroom focus has already shifted toward pattern behavior rather than isolated facts.
In the attempted home invasion, he violated a no-contact order, founded on the defendant's work, or founded on the victim's work, causing damage to the security. And it was so loud that it caused the neighbors to take notice and filmed the defendant leaving the scene. I also want to note that as far as his contact with the victim, he did text her, he contacted her multiple times, resulting in aggravated stalking charges. But one of note, which gave us concern, is on April 26th, saying, I don't know if I can ever forgive you. God is going to really have to help me through this time. He violated a no contact order, lied to the victim about what he was allowed to do, and appeared at her residence in violation of no contact. So it wasn't even just virtual or verbal violations. At this point, I would object. I also want to note that we had requested $100,000 on each of these files. On the attempted home invasion, we were only given a $5,000 bond, and on the aggravated stalking, we were only given a $15,000 bond. I'm not asking for an increase today, but I do think any reduction in those already small nominal bonds would be inappropriate at this time.
The text message that was cited by the state is the only alleged contact that he had that makes up the stalking that's a violation of any kind of bond condition. As far as the home invasion is concerned, the only allegation that suggests that he was even involved is the statement of the complaining witness. The alleged damage to the door, according to the report, indicates that the deadbolt was not broken, but the chain was. So the only way that he could have done that would have been to bend the door so far in that it broke the chain, but the deadbolt held. There's no damage to the door, which doesn't actually make any sense.
Motion for bond reduction denied.
Thank you.
And just like that, Judge Simpson shuts the door on the bond reduction request. Reduction denied. Short, direct, and final. After everything we heard throughout these hearings, missed court appearances, disputed explanations, alleged no-contact violations, stalking accusations, repeated procedural concerns, and arguments over public safety, the court ultimately decided caution outweighed release flexibility. That became the consistent theme across multiple defendants and multiple cases today. Accountability matters, compliance matters, and judges lose patience quickly when court orders appear to be ignored. One thing that stood out repeatedly was how Judge Simpson approached these hearings analytically rather than emotionally. He kept returning to timelines, behavior patterns, procedural history, and whether defendants followed through on responsibilities after being given opportunities by the court. That methodical approach shaped nearly every ruling we saw. We also saw how prosecutors strategically build narratives through chronology instead of pure emotion-stacking dates, violations, missed appearances, and communications together until the overall picture becomes difficult to overcome. Meanwhile, defense attorneys tried to humanize their clients through injuries, employment, family responsibilities, and procedural misunderstandings. But in the end, the court prioritized reliability and public safety concerns. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.